Michigan session, the Honorable Jason.
You may be seated. Does call the case, People versus Sebastian Compton.
Good afternoon, Your Honor. Attorney Ryan Ramsey on behalf of Mr. Compton is standing to my right.
Sir, your name?
Sebastian Compton.
Oh.
Your Honor, this is a sentencing matter. We've had an opportunity to review the pre-sentence investigation report. No additions, corrections, nor deletions to be made to that document, if I may elocute.
Yes, sir.
Your Honor, this is a first offense drunk driving for Mr. Compton. Sebastian, as I know him, is a young man who has a lot of bright future ahead of him. He is currently in between his junior and senior year at Eastern Michigan. The facts of this case are that he ended up in the hospital after an accident, drinking and driving. He has taken this very, very seriously. Not only did he put the public in jeopardy, he also risked his own life in this matter. Usually for somebody who's as young as him, 21 years old, he was old enough to drink, but not old enough necessarily to make the right choices in this case. He has been able to solidify within him the ability to understand his circumstances, to cease all alcohol, which during a junior year of college, living in a frat house has been, I think, pretty exemplary for him. He is employed during the summer at a country club where he earns money. He would like a payment plan if possible, Your Honor, as he does have a lot of student loans and bills. He's going to be moving in with his father for his senior year to get himself away from the influences of alcohol that were there at the college campus, save money, and hopefully have the ability to move towards a master's degree. He hopes to go to Michigan State to accomplish
For God's
that.
sakes, why?
Well,
Never mind. Go ahead. I'm sorry.
Just
That was
simply-
my own comment.
simply to be great, Your Honor, like all of us state graduates are.
Your state. Oh, man.
You could see it coming, couldn't you?
Yeah, I know, but I'm so done now.
We already surrendered our football.
There's
team.
one right behind you too,
I-
Mayor, and
We've already surrendered our football team to you guys. What more do you need, Your Honor? That being said, Your Honor,
they call that football. Go ahead.
Mr. Compton is here today. I've reviewed the various recommendations. He's already done the Mad Victim Impact Panel in this case. He does not have a problem with alcohol. The one thing I would ask, Your Honor, because of his work schedule, school schedule, it recommends AA once a week. Mr. Compton has not consumed any alcohol in several months. He's 21 years old. From what I understand of AA, most of the time it's really based upon the ability to understand other people's circumstances. In my own experience, having done this for 15 years, anybody under the age of 25, AA does not necessarily seem to be the best program for them. But outside of that,
Go ahead.
Your Honor, I think that an educational program would be something that he would be able to take advantage of. And again, having already had several months of sobriety, the continuation of sobriety, I think that he would be able to do a short period of probation, show that he has learned from this, and hopefully be on to those great things that he has planned in his future, including being a successful businessman. Thank you, Your Honor.
Anything you want to say?
Yeah, I mean, I want to say I'm sorry to you, the victim, the victim's family, my family. I definitely made some bad decisions and I don't want to repeat them. So,
Who's here with you?
my mother.
Mom, you want to say anything? I know you didn't expect me to call on you.
She's an all, Your Honor.
I never thought he was gonna give me a headache, and he gave me one in January. But he always been a very responsible kid. He always go, far and beyond, to succeed. His friends wanted to have jobs, at 16, and he wanted to save lives. So he became a lifeguard and a lifeguard. Then my mom is a lawyer back in my country, and we always thought that he's gonna be one because he's a good kid and he knows how to defend people. And he worked for a law firm. I always see him that he wants to reach five.
Brother, No, I got it. I'm hearing it.
farther where he needs to be a good kid. So I understand that it happened for a reason and he scared me horribly and I know he's very sorry and I'm glad he got another opportunity because something like that happened to him too,
Yes,
So I'm thankful.
yes, ma'am. All right, thank you. Sebastian, why do you think I asked your mother if she wanted to say anything?
Probably to see if I'm actually like a good human, probably.
No, I saw her back there between your counsel and you. And she just had her head down because all she was doing was sending up a mother's prayer about her son. Consider yourself fortunate for that young man. And it's not something I had no idea that was your mother, but I assumed that it was because of what her reaction really was. Young man, one of the things you should truly realize, and I think you are taking it seriously, the concept of having a head-on crash after drinking. The great blessing here is that you're here.
Amen.
And don't ever take that for granted. Okay.
I agree.
You can do stupid things because you're just of that age. I have some of my own self. They do stupid things. But once that's said and done, you have to truly take the lesson from it so that you don't do it again, that you don't put yourself at risk like that. You have a lot in this world, it seems to offer when I read through this report. And so you've got to give yourself an opportunity for that to happen. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of early intervention, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court, I'm placing you on 12 months probation. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $360 probation oversight fees. When can you pay that?
Would it be possible to have a 6-month payment on that?
Does he have anything today?
Unfortunately, he does not. He just finished school and he just started working at the country club.
When is he going to make his first payment?
I could do it as of next week.
Payday is tomorrow, Your Honor. He already was very excited about that.
So payday's tomorrow. So what are you going to pay by Monday?
Yeah, I could do. It's like I can do like around 300.
$300 by this Monday, the 17th. And the balance as directed by probation through a payment plan.
Thank you very much, Your Honor.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You are to complete an alcohol highway safety education program. I am going to order the AA meetings. I think that there is some benefit to that. I understand what counsel is saying. I just happen to vehemently disagree. You are to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation that has been completed. To continue your sober link for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1. The balance is suspended. Thank you.
Thank you very much, Your Honor, for saying again.
Hello. Court calls the case, People versus Samuel Dilworth.
Your Honor, Sam Bernstein was on behalf of Sam Dilworth.
Your name, sir?
Samuel James Dillard.
All right, thank you.
Your Honor, we have no corrections or modifications to make. Dilworth has found some stability following the offense through counseling, AA, and working with the sponsor. He's healthy now, and we're hoping that will continue. I'll have no problem knocking out this recommendation, Your Honor.
All right. Anything you want to say, sir, before I impose sentence?
Yes, Your Honor. I'd just like to again issue an apology to the victims in this matter.
All right. Very good. On count one, the malicious use of telephone service, count one regarding that charge. Sent to the court, place you on 12 months, prosecutor deferred sentence. You're going to pay $555 fines and court costs, $360 probation oversight fees. When can you get that paid?
Today.
Thank you. Pay that today. There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as directed by probation. You're to continue individual therapy, follow a recommended treatment plan with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. There's to be no contact with Kazim Fakai, I think it is, directly or indirectly. No assaultive or threatening behavior. Do not possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. I will set a review hearing on this matter to be held June 11th, 2025 at 9 a.m. I will order 180 days in jail that is suspended. On count two, which is the same charge, 12 months prosecutor deferred sentence, $555 fines and court costs. When can you pay these fines and court costs?
Today.
Thank you. Pay that today. Comply with all terms that I set forth in count one. I'll order 180 days in jail on that count suspended. Thank you.
Thank you.
Court calls the case People versus Guadalupe Cervantes.
Good afternoon, Your Honor. Dan Garrett on behalf of Mr. Cervantes.
Your name?
Guadalupe Cervantes.
Thank you.
We've reviewed all the reports. There are no factual.
Two Spartans.
I couldn't get through the start of this. Really.
Go ahead.
Yeah, but that guy thought you were Wolverine. Did you hear that guy?
I know.
Yeah. I thought you were going to say something.
Well, he's delusional. Anyway, go ahead. No.
Your Honor, on to Mr. Cervantes. She and I reviewed the report. There are no corrections. Believe the recommendation is appropriate. Ask you to follow.
Ma'am, is there anything you want to tell the court before I?
Nothing other than thank you for your consideration, Your Honor.
Pardon?
Thank you for your consideration, Your Honor.
Yes, ma'am. All right. Place you on the prosecutor's deferred sentence program for a period of 4 months. You're to pay $480 fines and court costs, $120 probation oversight fees. When can you get that paid?
Today.
Thank you. Pay that today out at the counter. Oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett, appeared with me. Mr. Woodley sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, misuse, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that unless misuse, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings, and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense. But also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern,
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No,
Was that said to the prosecutor?
that was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
Well, there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Is that, even as you describe it, amount to something that is grievable?
It doesn't.
And why was it said?
Because at the time I believed that it was grievable.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in front.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor. amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. This behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss and you
I did not.
if you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. Right.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule.
I felt this case was different because this is not a situation where, this is a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Savage.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, you know.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess.
All rise. State District Court for County of Washington, State of Michigan is now back in session. The hour of the day 7:50.
May be seated. Back on the record in the case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
The defendant. So it's very brief. And I don't want to have to bring the lay person back.
understand. Mr. Bennett,
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes,
Thank you.
will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this if it will work for everybody to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work for?
Yes. Thank you.
Oh, that's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as the prosecutor if you're going to self-report so that maybe others of us don't have to take any action.